Good morning, everyone. My name is Albert Chang. I'm the chair of the New Mexico Oil Conservation Commission. It is July 16th at 9 o'clock in the morning, and I'd like to call this meeting of the Oil Conservation Commission to order. Madam Chair, may I please have the roll, please?
Yes. Commission Chair Chang.
Present.
Commissioner Ampoma.
Present.
Commissioner Balin Lampkin.
Present.
And Commissioner Greg Bloom is not present today.
Thank you very much. We have a quorum. I will move on to I will ask to see if there are any discussion or amendments to the agenda.
I would move to adopt the agenda with the exception of hearing the goodnight matter first and not adopting the previous meeting's minutes.
Okay, it's been moved.
Second.
Okay, it's been moved and seconded that we skip consideration of the previous minutes and reverse the order of the cases on the agenda today. Is there any objection from commissioners?
No objection.
No objection.
Hearing no objection, so adopted. Moving on to the next item on the agenda as adopted, we're on to the pending cases, and the first pending case is now Goodnight Midstream versus Empire, New Mexico. So case numbers 24123, 23614 through 23617, 23775, 24018 through 24020, and 24025. I'll take appearances from the parties.
Corey Waymeyer on behalf of Empire, we're ready.
This is Jesse Tremaine for the New Mexico Oil Conservation Division.
Good morning, Commissioners. Adam Rankin with the Senate Bay Office of Holland and Hart, appearing on behalf of Goodnight. Thank you.
Nobody else with us, right?
Good morning, Commissioners. Mr. Chair, this is Miguel Suazo with Beatty and Wozniak, appearing on behalf of Pilot Water SWD.
Thank you.
Sharon Shaheen, also on behalf of Empire this morning.
Thank you very much. We left off about 2 months ago now, I think, with us in the middle of a discussion on Empire's motion that's pending. I think last we left off, the discussion was that the motion was seeking review of a letter from Deputy Director Powell, and I think, if I recall correctly, Mr. Waymeyer, there was discussion that it wasn't an order and that it was merely a letter. So I guess we're at a point where, I mean, I'll let you start if you have prepared remarks, but my question was first whether or not the commission should be taking up review of mayor correspondence, if that's where we're at. So.
Yes. We believe it's appropriately taken up at this time. And I think if you would indulge a little bit of the procedural history, not on the carrying case, but the last 2 months, I think is quite telling here. May I approach with a handout?
Sure.
First, on behalf of Empire, I'll just thank the Commission for all of the resources that have been spent on what's a very important issue for Empire and what we think is an important issue for the state of New Mexico. I want to, before getting into the prepared presentation, I just want to very briefly hit the forest so that we don't lose sight of the forest for individual trees. What the Commission found after months of testimony and documentary evidence is that there is, in fact, a ROZ here. There's a residual oil zone. We know that there's oil. The Commission found in its order that Empire alone has the exclusive right to produce that oil within the MSU. It found that there was substantial evidence adduced of future impairment and potential for waste in the MSU. And the commission found that there was migration of water out of the San Andreas into the Grayburg, and that was demonstrated by the work of Dr. Buckwalter. In terms of the future permits for new saltwater disposal, those were denied based on these findings. And the commission declined to order a permanent revocation of the existing injection, but did order it suspended based on that. So as we just set the stage for what we're asking for by way of the relief today, we know that there's residual oil, and the last question that was put back to Empire to come back with data is through execution of a pilot within Empire's discretion to prove to the commission's satisfaction that the oil there can actually be recovered using CO2. To put the volumes into perspective, what Empire's plan is, as submitted to OCD on the Form 101, 102, and 103, is the injection of 1,000 tons of CO2. To put that into perspective, that's about 5,600 barrels of what is effectively soda pop. Neither OCD nor Goodnight has been able to demonstrate any kind of harm that 1,000 tons of CO2 might cause to anything by way of injection. And to just juxtaposition that against the Goodnight injection, they're putting down about 150,000 barrels of water per day. You've heard testimony from Mr. McGuire that he doesn't know the chloride content of that water, that they haven't modeled plumage and plumes of where that water is going, that they don't know what chemical composition is contained in that water. And so to just kind of step back in terms of what Empire is trying to do here, what it submitted to OCD was simply putting down a reentry into a well, and that well is not even in the MSU at the moment, of 1,000 tons of CO2. In response to that, we got a letter that was actually termed by OCD the, quote, implementation order. We didn't call it the order. They said it was an implementation order. And we went through a series of correspondence. These were appended back to the motion that we filed in the first place here, where we tried to get them to revisit the idea that we would need to go in and amend the water flood order. For the part of Empire, there was precedent already established for not needing to go through a C-108 procedure to inject CO2. The two instances that Goodnight cites in its responsive papers were both water flood situations, not CO2. And in the Texaco situation, what we presented was past precedent via OCD that it could be done on a Form 103. In fact, that particular instance was a verbal approval. So I guess just before we get into it, as we look at the forest, the question would be, in light of this being Empire's MSU that it purchased and that it had the exclusive vested rights on, why is Goodnight fighting the injection of 1,000 tons of CO2? What concern does Goodnight have by way of this science exercise to come back and bring the commission the data it requested? For the part of OCD and its oil conservation mission, what basis does OCD have to resist Empire simply going forward to inject 1,000 tons of CO2? Now, it's been very clear here that the Goodnight objective is simple delay for delay's sake alone, because they know that every day of delay is 150,000 barrels of water that they're getting to put down into the earth for commercial gain. And so what this process has turned into one of gamesmanship, as opposed to allowing us to get going forward within the 3 years that this commission allowed so that we can bring back the data that was requested. I think here, if we go to slide 5, this was the remarks from OCD counsel at the last hearing that we had. It was said, quote, "This is not an order, it's advisory in nature. This is certainly subject to review." They're taking the position that this is an order from OCD. This is not concrete. OCD hasn't represented that it's concrete. At slide 6, this is more statements from counsel for OCD. This was just the beginning. It certainly wasn't the end. That's why that threshold issue was posed in the letter, just to elicit a bare modicum of OCD understands Empire's intentions are. At slide 7, this is what OCD assured the commission. Empire has provided something to OCD. OCD has to look at it and OCD is telling us that what they presented to the Empire is not in stone, is more flexible. At the next slide, council assured, quote, "We can obviously expedite it," meaning move quickly. And we would expedite review of this. It would be a top priority. So the irony here is that we submitted this on May 1st, 2026, and before the hearing, by all accounts, it looked like it was actually moving forward in an OCD system. After the hearing, in which OCD council assured the commission that they would expedite this review, they would review it, this wasn't a final order, it was an open discussion, they actually changed the status. And instead of it being reviewed, at slide 9, it got put on complete hold, pending approval of the OCC motion. So we came all the way out here in May. We had the hearing. We were assured by council that now that they knew that they had it in their system as of May 1st, they told this commission back at that hearing that we had done absolutely nothing. That was false, and we proved that we had submitted forms 101 and 103 before. It was moving forward, and they assured you it would be expedited. And then after this hearing, it had a complete halt placed on it. So we now stand in the unfortunate situation of coming back 60 days later, and nothing whatsoever has happened. There's been no action by OCD, and in fact, they stopped all action until we could have today's hearing. This is not fair to Empire. There's no reason that the review of that form should have stopped to simply put 1,000 tons of CO2 down into the earth. At slide 10, it was at the last hearing, we were accused of this not being a final implementation order, as they called it an implementation order, and that we didn't do enough to try to caucus with them. These are just simple examples of all of the efforts for us to cooperate with OCD to get their review and reconsideration of this idea that we would have to amend the water flood. I've highlighted, quote, "We are concerned that OCD's hold on the processing of the C-101 pending approval of the motion is contrary to the representations of the division at the May 13th hearing, as well as the expectations voiced by the commissioners at the time." So in our first motion, we presented the commission with evidence that in a series of correspondence, we tried to get OCD to actually give consideration and to move off of the implementation order. They said, quote, "We decline, and here are the basis for our declination." After this hearing, when we realized on May 13th that they had now put a complete hold, so exactly opposite of expediting and giving it prompt review, that they did exactly opposite, we followed up with correspondence raising that concern, and there's been no change of that status quo since the May 13th hold because we had to come back here today. So we are quite literally, from an Empire perspective, in a complete stoppage through no fault of our own. In terms of the jurisdictional questions, I won't dwell on this, Commissioner Chang, but at slides 13, 14, 15, this addresses the jurisdictional questions that you brought up last time. Very simply, we went through an entire process as part of the due process that Empire is entitled to have this commission make decisions, which resulted in affirming the denied permits and a suspension of the existing injection. And if there is implementation left to OCD, but OCD strays from the express direction given in the order by the commission, this is the only procedural mechanism left to Empire so that it can get on with its within its 3-year allotment. At slide 19, this just goes through, again, some of the procedural history. If you recall, leading up to the hearing on the second order, what OCD had said was they were proposing a 90-day program for Goodnight to shut in its wells, a phased 90 days to shut in per the initial order. After we got the second order, the 90-day implementation went completely out the window, and OCD's implementation letter arrived at a different procedure whereby Goodnight continues to inject and harm. And even despite the finding of OCC that future impairment has been proved by substantial evidence, that was a complete reverse course. We think that contravenes the order of suspension that the commission has. And so as we bring the commission concrete items that we're asking for action on here today, the chief one is that there is no basis for requiring Empire to amend that water flood order. There's no precedent for that in practice. There's no precedent for that in case law. There's no precedent for that in the rulemaking. And in fact, y'all posed that question, Mr. Chandler posed that precise question to OCD's counsel at the last hearing, said, why on earth would why would Empire have to amend the water flood order? They want to put some CO2 down into the ground. And OCD had zero explanation after filing papers resisting our motion and having time to prepare for the hearing. There was zero explanation for why on earth Empire would have to amend a water flood order in light of the pilot project that they were proposing. At slide 23, the implementation order fails to protect correlative rights. It deviates from OCC's final order in the sense that we do not have the 90-day staged suspension that was discussed by OCD in its written correspondence and at hearing. And now the injection will go on indefinitely unless CO2 is actually flowing into the ground. At slide 24, we talk about the scope of the project. If you read the implementation order, what OCD has thrust upon Empire is a stepping in and dictating what a pilot program must look like, the timing of the pilot program for it to meet the commission's opportunity to decide if it's successful or not. And that is not the pilot program that the commission ordered. It is not a pilot program that Empire is under any compulsion to perform. If you look at the idea that the 108 would be required and that there's an amendment to the water flood, what that's referring to would be a full-scale CO2 flood, basically an actual EOR process. The pilot that Empire has proposed here is a huff and puff, and for such a small-scale project as a huff and puff, again, to bring back hard concrete science and data for this commission to prove that the oil moves with the injection and soaking of CO2, there is no reason that that water flood order would need to be revisited. At slide 25, this is just the volumes of the existing water flood. The idea that we're going to amend the water flood order that has been out there for decades. We are still presently executing the water flood as we speak. We continue and intend to continue executing the water flood. There is no reason that water flood order needs to be revised or revisited. At slide 26, we just go through different bases for why that water flood order doesn't require amendment, and we make the point again at the very bottom that Mr. Chandler questioned OCD at the May 13th hearing, why must this water flood order be amended? And there was zero explanation, and in review of the papers, there's been zero explanation or support for why that water flood order would need to be amended. We all know as a practical matter why Goodnight wants it amended. Because there is no possible way that going through all the processes to get that water flood order amended, we can come back within the 3 years we've been allotted to perform. And we made that point at the last hearing, that how on earth as a practical matter is Empire going to be able to perform within the 3 years if we have to go through that amendment process being fought by Goodnight and delayed by Goodnight and OCD along the way. And we didn't hear any opposition or argument, any shape, form, or fashion that we were off on that there was some way that could possibly be accomplished within the 3 years that were allotted. These are details of the pilot project that has been pending with OCD going back to May 1st of 2026. At slide 27, this was filed on forms 101, 102, and 103. The CO2 project goes into the John Knox well. This is Yates, Seven Rivers, and Queen intervals that are going to be squeezed off, pressure tested. This is not an MSU well right now. The San Andreas formation will be perfed at 4150 to 4200. The zone gets acidized, swab tested to inject CO2. Bottom hole pressure is taken, 1,000 tons of CO2. Well will be flowed back and tested with a third-party test separator. Results will be utilized to verify residual oil can be mobilized with CO2. Again, we may have additional locations we want to attempt to huff and puff on as well, but the first one is starting here to see what the results are. But we can't even get kicked off on this to satisfy our 3-year because of the opposition by Goodnight. And again, if you come back as a practical matter, why does Goodnight oppose this? It's just to the ends of establishing that oil can be moved here in the San Andres for the benefit of Empire and for the benefit of the royalty owners, the state of New Mexico, and the BLM. The wellbore diagrams were provided at slide 28. At slide 29, these are the two examples that Goodnight cites as precedent for requiring an entire C108 process. Each of those were both water floods. I just don't want that to be lost. Those were both water flood injection. What Empire has proposed here by way of the plan it submitted back on May 1st, 2026 is not water flood. It's injecting 1,000 tons of soda pop. At slide 30, this is our express precedent by OCD in the central vacuum unit where a huff and puff was approved even verbally in that instance on forms 103. We initially submitted on form 103 and we're told to go back and by OCD staff to submit on form 101. That's why you see a 101, a 102, and a 103 as part of the May 1st submissions.
If I may briefly interrupt, so I tracked the 101 and the 103. Where did the 102 come from? Or when was that submitted?
I wish I had Ms. Hardy or Ms. Shaheen. No 102?
We filed a C-103. They asked us to file a C.
Okay, I thought there was a 102 as well. That we filed the 103 first, and then commission staff asked us to file a 101. I apologize for creating the confusion.
So no 102, right?
I don't think a 102. That's correct.
Generally, a C102 is required to demonstrate the location of the well. I mean, generally, that's usually submitted.
No, I understand, but was there one filed in this case? I don't think I didn't see it.
I don't believe so. I apologize. Okay. In my paper, there's probably a paper that references a 102, and that's an error on my part.
No worries. I just want to make sure I track and didn't miss anything. Thank you.
So coming back to slide 32, again, this is a situation where the commission has already found that Empire has the exclusive right to decide how to best extract oil. In this instance, in terms of coming back to the commission with the data requested, we've identified a huff and puff as the most reasonable and appropriate way to come back and bring that science. If you look at the implementation order by OCD, which again, through a series of correspondence, it's in the record, we asked them to reconsider and they said, we decline and here are the bases for our declination. These were multiple attempts. These were multiple attempts in writing. The attempts have followed the last hearing. You saw the correspondence that we sent on May 13th, 2026. We are still here, no closer to being able to execute the work required by the commission than we were 60 entire days ago, after being assured that this would receive, after the commission was assured that this would receive expedited consideration. OCD did file papers. None of the papers explained or provided any insight whatsoever as to what's happened on our C-101 application over the last 60 days. If there's any questions, I'm of course happy to field those. I appreciate the commission's consideration of this. This has gone on long enough. Absolutely, the OCC should be able to implement, to ensure that its order is properly implemented. That's all Empire asks for.
Okay. Unless commissioners wish to ask questions right now, I figured I'd let at least each party give us their take before we go to questions, if that's okay with commissioners. Okay. No
I'm okay
opposition.
with that.
Good night.
Thank you, Mr. Commissioner, Chair, and Commission members. May it please the Commission. Based on Empire's filing of a C-103 seeking authorization to inject CO2 for an EOR pilot project at the end of April, after completion of briefing on their motion, and an APD to convert a single well into a CO2 EOR huff and puff at the beginning of May, just prior to the hearing that we had last. That's when we first learned about the their proposed administrative filings and the proposed pilot project, after briefing had already been completed on their challenge to OCD's, not an order, it was directions, and they attached it to their briefing here, and you can see it's titled Implementation of OCC Orders, and they say that they're providing the below directions. It's not an order, it's a correspondence that provides guidance in the vacuum because there's been no submission by Empire at that time. So there was no action that OCD was taking, it was simply giving guidance on what it understood the order from the commission to require. Now, because this is simply seeking an advisory opinion, the motion that Empire filed, it's improper. The issue is not right before the commission. Since Empire's motion is fully briefed, Empire has made two filings the APD and the C-103, and OCD has not acted on either one. The commission should wait and not wade into any inchoate controversy until the division has actually acted. Now, in our view, the only action OCD can take on Empire's administrative filings is to reject both of them. First and foremost, because Empire is not in compliance with OCD regulations governing inactive wells. At the last hearing, they had 21 inactive wells. 2 months later, they're up to 25 inactive wells. That's more than 3 times the limit under the division's current regulations. Neither APDs nor EOR projects can be authorized or approved under express division regulations unless the operator is in compliance with the inactive well rule. They can't go forward until they get that done. What have they done in the 2 months since this has been brought to their attention? Actually, it's been more than 2 years that they've been out of compliance. Nothing. It's only gotten worse. Since Empire first acquired its interest in the unit, it's been struggling with its inactive wells, and they remains the case. And rather than fixing the problem, it's just getting worse. Now, it's only going to get worse going forward because, as you all know, the commission just approved an updated financial assurance and plugging rule that's going to eliminate the 7-well cushion that Empire currently has for operating fewer than 1,000 wells. So now, as soon as that rule goes into effect, they're going to have 25 wells out of compliance. And out of all the wells that they operate, 441 production wells, 25% of them, a quarter of them, are producing less than 90 barrels of oil equivalent. So that's going to just put them in a desperate situation. Now, the other problem that Empire has is that they're not following the regulations. And Mr. Waymeyer was addressing that through his presentation this morning. Under the rules and under the commission's order, it's very clear that they must follow the regulations that the division has before them governing UIC EOR projects. That includes requiring them to file a C-108, going to hearing, amending the water flood order, which is simply getting a C-108 approved, and then also, in our view, amending the statutory unitization order. Both the water flood order and the statutory unitization order that currently authorize enhanced recovery in the unitized interval of the EMSU are tied. They go hand in hand. They reference one another. The unitization order expressly references the water flood order. The Unitization Act requires the operator of the unit to provide and demonstrate what type of operations they're going to undertake within the unitized interval. They've been approved for water flood. The water flood order under C-108 authorizes them to inject water for secondary recovery. Under the division's regulations, they're required to file a C-108. That C-108, upon approval, would be the modification of the water flood order, allowing them to also inject CO2 as part of a pilot project. The central vacuum unit example that Mr. Waymeyer pointed out, while it's true that for somehow they got verbal or written approval on a C-103, within months they were required to come back and file a C-108 for hearing. And it wasn't a full water flood that they wanted, rather a full CO2 project that they were seeking. It was simply a CO2 pilot project for part of the central vacuum unit. They weren't seeking a full-on CO2 project. It was simply a pilot project. Same rules apply to Empire. But rather than follow the guidelines that the division has provided, rather than follow the express regulations that every other EOR operator must follow, and I know this well because I do many EOR projects, including CO2 pilot projects. Every CO2 pilot project I have ever done and got approved has been required to get a C-108. It's express in the regulations. Any EOR injection must submit a C-108. That's part of the UIC primacy that governs OCD's authority to regulate these projects from EPA. It cannot be avoided. Now, instead of trying to choose a different path after being shown the proper way to proceed and having received resistance and feedback from the division, Empire instead has chosen to double down on its positions. And rather than focus on its 3-year window to implement the pilot project and file the proper applications, it's filed now more than a dozen applications with the division to revoke the injection authority of 4 different disposal operators in and around not just the EMSU, but the Arrowhead Grayburg unit. So rather than actually focusing on the EOR project that they said they were going to do, they're now targeting additional operators through the division to shut in their wells. And they're doing that at a time when they still haven't done what the commission has told them they need to get in order to accomplish that, which is actual data. So rather than focus on what they're supposed to do and the way they're supposed to do it, they're going out and seeking to revoke the injection of multiple additional operators around the EMSU and AGU. The whole point of the division's engagement with the rehearing process, when both parties filed an application for rehearing to review the commission's order, the commission engaged in that briefing process and made clear to the commission that any order issued by the commission has to authorize the division to and make clear that Empire is required to follow all regulations governing injection. The commission adopted that approach, made clear in their order that all regulations are required to be followed, baked in this process into the order. When Empire challenged the order before the district court, they didn't raise this as an issue. They didn't. That issue has sailed. They have no opportunity to challenge it now. Their opportunity was to raise it before the district court. It wasn't among the issues that they challenged. There's no opportunity for them to challenge it here. It's improper. So at least, especially in the case where it's simply a advisory opinion from the division on how to proceed. If there's actually an action on an application where there's an actual controversy, an actual issue, then I think they would have an opportunity to challenge that at the time. But here, it's just purely advisory. Here we are more than 7 months after the division issued its guidance. And rather than pursuing the path of least resistance, which is a clear pathway for them, under the regulations, they've chosen instead to steadfastly choose the harder path, which is the path that is not available to them, which is to violate the regulations and try to short circuit it. If they had simply just gone the right way, we would be in a different position today. That includes fixing their inactive wells. So a few other things. I think I covered everything that Mr. Waymire raised, but I want to make sure that I have addressed them. One of the concerns, I guess, is why OCD, and the OCD can address this. Well, first of all, what is Goodnight's concern? Why are we fighting this? Well, we're not necessarily fighting it. We just want the rules to be followed. There should be a level playing field for everyone. Goodnight was required to go to hearing for its injection under the UIC regulations, just as Empire should be required to do the same. Same is true for every other EOR operator in the state. They all have to go through to get their C-108 approved. I believe the same approach or same justification would apply to OCD. So after they filed their application, their administrative application, I think, the division can speak to this, but I think the division was probably thinking, what are we to do? We have a motion pending. Should we, if Empire had simply withdrawn their motion after filing their administrative application, I think that would have put the division in a different position. Instead, it maintained its motion before the commission, requiring the commission to address the issue. I think it put the division in an awkward situation. As to the issue about the 90 days, alleging that the division has somehow backtracked from its original position that it was going to require Goodnight to cease injection within 90 days of issuance of a commission order, that was never the case. The division simply said that the minimum time that they believe would be reasonable for an orderly, timely shut-in would be 90 days, not that they were going to require Goodnight to suspend injection within 90 days. That's just a mischaracterization of what went down at the hearing and what the division's position was, and I think Mr. Tremaine can address that himself. But that was never what the division's position was at the time. I think I've addressed all the issues that Mr. Waymire raised. If commissioners have any questions, I'm happy to address them. Thank you.
I guess I'll turn to the division next.
Thank you, Mr. Chair. Candidly, I'm not sure where to start. We've had a lot of discussion about trees this morning. And a lot of those trees are issues of what has been discussed, have all been post-motion. So a couple things just to put this in context. OCD currently has about 185 APDs that are in pending review process that have been submitted since May. There's 73 at least that were submitted prior to May. The resolution of the current C101 is completely in keeping with the normal workflow and resources available to the division and is under review. As was noted at the last hearing, Empire did not notify OCD prior to that hearing that they had submitted the pilot project and that there was anything extraneous or urgent that needed to be reviewed. That was a surprise to council and technical staff that was in the queue with the other filings. I think the motion here is not appropriate for a determination at this time because one, it may be potentially dispositively resolved by the appeal in district court, and two, we expect it to be rendered moot because the division will be making a determination. I expect a determination on the current C101 sometime this week. There's a number of problems with that submission. I'm not going to get into the exact enforcement status, but the division currently, the division initially entered appearance in this case back before all the water flood discussions because Empire had substantial compliance issues. That is something that we have to look at when reviewing new APDs and other projects. Additionally, based on the content of that substantial hearing that we've talked about extensively, OCD reasonably expected a relatively large-scale pilot project that would demonstrate two things, or seek to demonstrate two things. One, product, and two, long-term recoverability. Our technical team, looking at this one well Huff and Puff project, does not understand how this demonstrates long-term recoverability. So there are this argument that because of the order 24004, Empire does not have to comply with other division rules, I think is a red herring. There's nothing in that order that says that this is a different process or procedure. As I said, we expect a determination on the C101 imminently. In response to Mr. Waymeyer's presentation, the C101 review was never held. There was a status placed in OCD permitting that they've noted in their slide deck. That was removed by Deputy Director Powell. The OCD was reviewing that submission during this process, but because of the other issues that I've implicated, that process is taking longer than expected. Or it's actually a normal review process, but it is taking longer than an expedited review process would be expected to take. The pilot project was not what was reasonably expected. There's questions about the well that are proposed, and the division has to resolve approval of the APD within Empire's compliance status. I will leave it at that.
Any other parties wish to weigh in online?
Yes, thank you, Mr. Chair. Again, Miguel Suazo with Beatty Wozniak appearing on behalf of Pilot. I'm not going to rehash the arguments and points made by Mr. Tremaine and Mr. Rankin, but I think it's safe to say the Pilot supports their positions and arguments as made in briefing and made before the commission today. Pilot requests that the commission deny Empire's motion and affirm the division's implementation decision. And even if the commission concludes that it retains authority to address implementation at this stage, Pilot thinks that the immediate shut-in request should still be denied. From Pilot's view, the commission gave OCD discretion to implement the suspension on a schedule that the division deemed necessary to provide Empire an opportunity to establish a CO2 EOR pilot project, and the division in this case exercised that discretion. It didn't refuse Empire an opportunity, but what it did do is it provided a pathway that they don't seem to want to follow. I think the rules are clear. 1915-26-8 requires injection authority for wells injecting fluids for EOR to submit a Form C-108, as Mr. Rankin adjusts, and that same rule requires EOR recovery injection projects to be set for hearing. And then 1915-5-9 also imposes operator compliance requirements, including inactive well compliance requirements, as Mr. Tremaine raised for the commission's consideration. those rules apply across the board to all operators, and they're intended to protect correlative rights, prevent waste, and maintain the integrity of OCD's permitting process. And that's, I think, all that Pilot is asking and the other parties are asking for here. That concludes my statements on this matter.
Thank you very much. I don't think there's any other parties who wish to speak today on this. Okay. Do you have questions?
Yes, I do.
I'm sure we've got questions.
Mr. Chair, thank you so much. And if I'm just getting so much into the weeds, you have to prompt my attention to that. But there are some few things that I just need to discuss briefly. So I'll start with good night. So based on your submission, it sounds to me that you are saying that before, let's say, even Empire can proceed with the pilot project, it is your view that even the unitization documentation, or let's say even that the approved unitization order needs to be amended. Is that correct?
Dr. Ampoma and commission members, the original operator of the unit followed the Statutory Unitization Act for a reason, and that was because not every owner voluntarily committed its interests to the formation of that unit for secondary recovery. When that's the case, the only way that a unit operator can proceed with secondary recovery, tertiary recovery, any form of enhanced oil recovery, is to invoke the power of the states to use its police power to compel those interest owners to force their interests into the unit. Okay, and that's a severe action. And in exchange, the Statutory Unitization Act requires the operator to demonstrate that the costs they're going to undertake and the effort they're going to take by using other folks' mineral interests is going to result in a positive outcome. Okay, it's going to result in an economic recovery, which is why under the Statutory Unitization Act, it requires operators to make that showing on the front end. Okay, so that's number one.
Sorry, here's Super Hornet. No, it's interesting.
So that's what the Statutory Unitization Act requires. And it requires it because the police powers of the state are being invoked to combine the interests of these mineral owners against their will. Along those same lines, in order to undertake an EOR project under the UIC code and the regulations that were promulgated by the division, in order to obtain primacy from the EPA, authority to do it, requires them to follow those concrete steps to get authority for EOR injection. So when they undertook the EOR project initially, they filed a C-108 for secondary recovery of minerals through a water flood. As part of that demonstration with the Unitization Act, they also had to show how they were going to allocate production among those owners whose interests were taken. Okay, so they had to show how they're going to do that, and they did it at the hearing. They showed that there was going to be a fair allocation of production based on the water flood. In that instance, because it was targeting only the Grayburg, there was some primary production remaining. So they had to show how they were going to account for the difference between primary production and secondary production. So there was a very complex showing on how they were going to allocate production at the time of the Statutory Unitization Act. Here, okay, Empire is seeking to use the Unitization Act as a sword, as a weapon against Goodnight and others to say, look, we've been given exclusive rights to produce this unitized interval, okay? And that's true. Under the Statutory Unitization Act, they were given the exclusive right to produce minerals from the unitized interval, okay, including the San Andres, which was unitized. The difference is that the San Andres has never undergone primary production, and it's not part of and therefore the allocation formula that was proposed cannot be applied for tertiary recovery in the San Andres. Okay, there needs to be a new allocation formula. There isn't one. One's not been proposed. We don't know how those interest owners who stand to benefit or not benefit are going to share the costs or production because it hasn't been amended. We haven't heard a thing about it. So under the rules, under the law, because the entire unitized interval has been essentially authorized for Empire to produce. It's been authorized for the sole purpose of water flood recovery because they've been able to show that it can generate a positive recovery. If they want to do some other form of secondary or tertiary recovery, they have to go back and amend the Statutory Unitization Act to show that it's going to have a positive recovery and to show how they're going to allocate the production among owners to protect their correlative rights. So that's why ultimately the Unitization Act needs to be amended, and council, who's not present right now for Empire, acknowledged that that was going to be required. At some point, they're going to have to amend the Unitization Act to account for the requirements of the state law. Okay? My point is simply that now that they want to actually do the project and they want to produce unitized substances from the San Andres, the time is now. There's one order that governs how the unitized interval is to be produced, and that's the Statutory Unitization Act, in concert with the water flood order, which is simply recognition that they have been authorized through a C-108 to inject for water flood for secondary recovery. What we're saying is that what they need to do is amend the water flood to authorize in addition to secondary recovery through water flood, injection through CO2. That happens all the time. Operators of water floods that seek to move into transition into CO2 amend their water flood order to add additional fluids, including produced gas sometimes, and CO2 to authorize them to inject for enhanced oil recovery. So because those two orders operate in concert, the water flood and the statutory unitization order, both must be amended because that's what governs the production of unitized minerals within the EMSU.
Thank you for the education there. I appreciate that. I will ask OCD one question. Yeah, so it sounds to me that in your submission, you said that OCD is based on the order that the commission signed off on. OCD believes that a full-scale CO2 EOR will be required to justify the recoverability, not necessarily a pilot.
I'm simply representing what has been relayed through our technical staff that this has to be reviewed in the context of the objectives of the intended pilot project. And I'm not saying it has to be a certain size or any specific criteria beyond the direction provided by OCD's technical staff. When the APD was submitted, and this is what OCD understands to be the scope of the proposed pilot project, it was not what was expected. OCD reframed its analysis and looked at this well in isolation. I'm simply highlighting that what was discussed at hearing, what was expected from OCD was not what we got. And it needs to be looked at in that lens. Now, this is one well. There are questions about the well independent of any compliance status. So I'm not able to answer that, Commissioner Ampoma, from a technical perspective. I was not representing that there's a particular size or number of wells. It's just that this was, based on the record, not anything like what OCD expected.
Is it OCD understanding that the burden is on Empire to prove to the commission that the ROZ can be recovered? And so I'm not sure if OCD is more or less pushing those envelopes to the, let's say, to the extreme end. I mean, I'm trying to understand how there was no much discussion from OCD to the commission with regards to how the pilot is going to be, during the hearing. So I'm a little bit concerned as to the scope, because let's say if it is Huff and Puff, it's one well. Or let's say they could have chosen to do a pattern-based, let's say pilot, which could be one injector, 4 producers, or let's say 4 injectors, 1 producer. And they chose Huff and Puff. I mean, was that not at their discretion? And they're just looking for answers to respond to the commission.
No, thank you, Commissioner Ampoma. I think I can rephrase and explain. So I'm responding to Mr. Waymeyer's lengthy set of allegations that the division took too long or put this on a hold. It was not on a hold, did not. So I'm explaining the division's process, that it was in fact reviewing this. It did reframe its expectations, looked at this project in isolation, and is responding to that, reviewing the C-101, and we expect that decision imminently. I am not suggesting that there's a determination on this individual C-101 based on some other factor. There's this question about what happened in the last 2 months. That's the explanation I'm providing to the commission.
Thank you.
Commissioner Lemkin?
Yeah, I think I just have one question for Mr. Waymire and Empire in general. What was the reasoning for choosing a non-unit well to implement the pilot, and why is it Empire's belief that that project would be covered under the unit agreement if it's not a unit well to begin with?
Correct. So in this, I wanted to clear up one point of confusion that I created twice now. The C-102 was in fact filed with the C-103. So I don't think it shows up as a standalone, but it was attached. But to answer your question, Commissioner Lampkin, there were a number of vertical wells out here that Empire has operational control of, as you heard. This particular one's completion interval is not in the MSU right now. They looked at that well, and from a wellbore integrity standpoint, and in terms of its location on the structure that we heard all of the geology testimony and engineering testimony from Mr. West, based on its location on structure and based on the wellbore integrity, they identified that as the best candidate to come back into. As you look at that wellbore schematic and diagram, it will be physically in the MSU after the new perforation and plug back procedures are set. So it will be producing San Andres in the MSU. And in terms of that particular well chosen, in terms of no prospect for productivity, in terms of its open intervals at the time, its location on structure and wellbore integrity, that was the thought process.
Do you think that convolutes the process for seems to be the basis of the arguments between the OCD and Goodnight in terms of needing to return to hearing and amending orders and such to choose a well of that nature?
I do not. And so again, this is a well that you'll recall the counsel for Goodnight here led an argument. So we have all of this paper. At the last hearing back at May 13th or May 1st, there was a question appropriately posed by Mr. Chandler of what on earth does the inactive well list have to do with anything? And that was the argument they started with again today after having it put to them numerous times. What does this have to do with anything? We've been working on that inactive well list. In terms of going back and taking this well, it's actually one last inactive well for anybody to fuss over or have concern with. And so again, the wellbore diagram shows where the plugs will be set. And so we will now be in MSU depths, and it's just 1,000 tons of CO2 to explore recoverability. I did want to comment very briefly in terms of what the pilot looked like. During the months of hearing testimony, Empire never committed. We obviously needed to see what the commission's final decision was, period. The idea of the 3-year and the pilot program, we didn't know that's where the commission was going to go. We embrace it. We're trying to execute on it. But we certainly didn't say what the program was going to look like. And I think that what may have been lost in a little bit of this conversation is it's not OCD's discretion under the 2 final orders in this case to decide if the pilot is successful or not. The commission kept that continuing jurisdiction to say we're not ordering a permanent revocation at this time, just a suspension. Perform your pilot that you in your discretion exercised determined to be appropriate, and then come back to us so that we can make the decision. And the hazard lies with Empire. If what we've done is not good enough for the commission's satisfaction, we bear the consequence of that. That's not OCD's decision under the final orders that we have.
Okay. Thank you. I have some comments and perhaps questions. We'll see if, I recall, I'm looking at the transcripts that, or snippets of the transcript that Empire has provided, and we all sat through this, so I also recall OCD's counsel at the time representing that any review of any application could be expedited. So I think I understand why Empire would be, at the very minimum, confused, if not alarmed, by a note that says hold pending OCC motion. I am currently not aware of any reason why. I mean, it's just a note in a summary, so whoever put this in the notes, hold pending approval of OCC motion. I'm hoping that was mere confusion, but is there any reason why OCD thinks this commission should need to hold, that this is an act, or, I'll let you respond.
No, Mr. Chair, and I skipped over that point rather quickly. That was a complete misfire. It was not identified as the status. Mr. Powell is not aware of the status until after some of the filings in this case. He has corrected it. The staff have been reviewing this project. The rest of my presentation was just simply explaining what has gone into that review and how it is actually consistent with OCD's normal review process.
Okay, so to the extent that if any one particular staff member at OCD may or may not have misunderstood or either erroneously put that note into the system or misunderstood what OCC intended, it's the position of OCD now that there's no reason why OCD wouldn't be able to proceed reviewing the C-101 with all deliberate haste.
Correct, and it was not and is not held.
Okay. That's consistent with my understanding as well, that there's, at least from the commission's perspective, from my perspective, I wasn't aware that we had, and I certainly did not intend to have anything pending here at the commission that the division would need to wait for. And it's my understanding from the presentations today from both Goodnight and Empire that however the division decides on the 101, I think Mr. Rankin has stated on the record that he believes the C-101 should not be granted, so I imagine he would bring this back to the commission's attention if it is granted. And I imagine the position of Empire is that if the C-101 was denied, that Empire would wish the commission to review that, right?
You've stated that very succinctly and accurately. Okay. You brought it all right there.
So I imagine all of the various issues, and of which there's many points of disagreement between the parties here, and questions from both my fellow commissioners about the details of what is going, or I shouldn't say details, but many of the points of contention in this case would invariably be relevant should that C-101 decision end up back here at the commission. So my current recommendation to my fellow commissioners is that I am hesitant. I understand that the letter Deputy Director Powell issued sounded fairly authoritative and very direct, provided fairly, I don't want, what's the word I'm looking for here? Clear, bordering on, I'm sure Empire feels a strident direction on exactly how they should proceed. But I hesitate to open a precedent of this commission reviewing correspondence lest all the other parties in every other case start asking this commission to start reviewing all of the emails that might fly back and forth. And I think we've got a pathway for all of the issues that are in front, that the parties wish to raise, to come right back before the commission unless the OCD somehow is able to magically grant a decision on that C-101 that satisfies both parties, for which I will knock on wood that somehow the division can get to a decision on that C-101 that satisfies all the parties in this case. But unless that happens, all of these issues are going to come back in that particular forum. So I will open the floor and take my fellow commissioners' opinions. But my current inclination is to decline the consideration of this specific motion and take up the issues when the C-101 decision is back before us, noting that the commission has instructed OCD to proceed with all deliberate haste, all possible haste, to act on Empire C-101. And I'll open the floor to my commissioners.
Yeah, Mr. Chair, I do agree with you on that. And then even in your recommendation, as you said, we are clearly saying that there's no reason why OCD should not proceed, with the review of the application. So I do second or support your recommendation on this. Thank you.
Any thoughts? Any thoughts, Commissioner Lamkin?
No, I tend to agree with you guys' synopsis.
Okay, in that case, I think it's a procedural order. I mean, I'm happy to take a motion to make that formal, but otherwise, I think what we're going to do is procedurally, we're not getting into the merits. Many of the merits raised are indeed important and should be explored by the commission, but I think that will come when and will be more procedurally proper when there is a division order on those C-101s for us to then for us to fully consider.
May I ask one point of clarification?
Please.
So just so the record's clear, the motion presented by Empire to require modification of OCD's implementation order is not denied. This issue is being carried until we have some direction on the C-101 application, and it would come back as part of a package of decision.
I would rather that you basically raise the same substantive issue. Well, let's hope that somehow everybody walks away satisfied with the C-101 decision. But if that is not the case, you're welcome to raise those same substantive issues, but I think it would be cleaner for my record if you're able to just rebring that as an appeal of the C-101 as opposed to continuing the motion in front of us, if that makes sense.
It does. And just with the issue, I guess, in the mind of Empire, first, thank you. We appreciate the attention and action. The common thread is this idea of having to go back through the full amendment of the water flood, and we still haven't heard anybody say we're wrong about the timing if we're going through an amendment of the water flood. So we just didn't want there to be any argument that that issue has been decided and denied by today's action.
Well, I don't know that I think what I'm recommending, so let me be clear about what I'm recommending to the commission, is that we decline to take up the motion to revisit or to consider the letter. So I don't think we want to get into the merits, but you're welcome to raise the issue about the water flood when there is we would like OCD to be able to explore these questions with you at the division level first, so that so hopefully you can talk to the technical teams first about exactly what the water, whether or not there is a water flood, what requires amendments. My understanding is that the correspondence thus far, right, not the filings in this case, but the correspondence between Empire and the division is the division's attempt to figure out what the commission's meant when the commission said that all applicable and relevant regulations still apply, right? And so the division has made what appears to me, the division has made an attempt to lay out what they perceive as the relevant and applicable regulations in the absence of a application at that time from Empire. Now that there is an application, the division will now have to make a formal decision. And once that happens, you're welcome to come back to the commission. And if you're dissatisfied with that order, and we will, at that time, we'll take up all of those concerns if they're hopeful. Well, again, I can only hope that there are no concerns left, but given that there are likely to be concerns, or if there are concerns, then we will take all of that up through the procedural mechanism of of an appeal of an OCD order.
Thank you so much for the clarification. That helps a lot.
Thank you very much. If that is the commission's decision, I would be happy to entertain a motion to so adopt, and then I will write that all up in a hopefully more detailed written order for the parties.
Yeah, Mr. Chair. So the commission finds no reason that OCD will need to wait for anything from the commission to act on Empire's C-108 application at this time. The commission expects OCD to act on the application with reasonable and deliberate promptness. Also, the commission does not adjudicate mere letter correspondence. Therefore, this matter is not currently ripe for review by the commission. OCC review in this matter would be available only after OCD has issued a reviewable order. Therefore, I so move that the commission declines the consideration of Empire's instant motion seeking view of Deputy Director Powell's letter.
A second.
Moved and seconded. Is there any opposition from any commissioners?
No.
Hearing no opposition, so ordered. Thank you all very much.
We additionally had the pending issue of our motion to lift the stay and set status conference, and also Goodnight's motion to dismiss without prejudice. There was a little bit of confusion as to whether that particular, it was initially reflected as an agenda item, and then I think that yielded in favor of a more general description. We're ready to proceed, and if the commission's not ready to proceed, we can take that up at the next audience.
We are not, but we can, if you wouldn't mind following up with our commission clerk. I understand that time is of the essence for Empire, so if we need to set something quicker to try to get you guys that, to get that moving, we'll do that, and we'll see what we can do to get that set as quickly as possible.
That's perfect. So as far as the commission's concerned, does that conclude the Empire matters?
That's all we're ready for today, I'm afraid.
Thank you very much. We appreciate your time.
Thank you.
Mr. Chair, can we take about 10 minutes break or so?
Yes, that's fine by me. Let's take a, let's see, it's currently 10:08. Is 10:15 sufficient time? All right, 10:15. We'll take a recess until 10:15. Thank you very much. Thank you all. Sorry for the delay. It's now 10:20 or 10:21, and we're back on the record, coming back from recess. The next case in front of the commission is case number 26206, application of Marathon Oil Company for de novo hearing on order number R24349. I'll take appearances and then we'll turn to Marathon.
Good morning, Mr. Chair, Commissioners. Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of the applicant in this de novo application, Marathon Oil Permian. And with me today in the audience is a Marathon representative, Ms. Carrie Hatley. We appreciate your consideration of our motion. Thank you.
Good morning, everyone. Ben Holliday on behalf of Powderhorn Operating.
I'm sorry, say that again?
Ben Holliday appearing on behalf of Powderhorn Operating.
Got it. Okay. I will turn to the movement. You are the mover, right? Here? No, you're the, I'm sorry. I got them backwards. Okay, Go for it.
Good morning, Mr. Chair, Commissioners. This is a stay for the division's underlying order. It's not about delaying development, but it's about preserving Marathon's statutory right to a meaningful de novo hearing before Powderhorn's drilling makes that hearing academic. Without a stay, Powderhorn can commence drilling operations immediately, which would substantially undermine the purpose of Marathon's de novo challenge and inflict immediate irreparable harm on Marathon's correlative rights. The division's order underlying this hearing conflates or combines all working interest ownership across Powderhorn's proposed 959-acre Super Hornet unit, rather than evaluating working interest control in the overlapping contested acreage, which is the analysis the Commission's precedent establishes. Marathon controls 100% of the working interest in its 320-acre overlapping acreage, which is the north half of Section 2. And it's under its proposed Campana development project under a still active 1976 joint operating agreement to which Powderhorn itself is a party. All we asked today is that the Commission preserve the status quo just as it did in the recent Coterra Permian Resources stay involving the Reed and Stevens applicant until the merits can be fully heard and fully and fairly heard. So a stay requires a four-factor showing: likelihood of success on the merits, irreparable harm absent a stay, and then no harm to the non-movement, here Powderhorn, and no harm to the public interest. And we believe that we satisfy each of those factors, and Powderhorn cannot rebut a single one without relying on facts and legal theories that the Commission's own precedent forecloses, that we outline in our reply brief. This is not a novel remedy. The Commission granted precisely this relief, as I mentioned just recently, in a case where Permian Resources had won an underlying compulsory pooling case. Coterra challenged it. And in order to preserve the rights and make sure that all parties had a full and fair hearing at de novo, the Commission granted the stay. And then the parties went on to a hearing timely and were able to have a full hearing before the Commission. And even though the Commission ruled in favor of Permian Resources and against the movement who sought the stay, nevertheless, the stay was proper because it allowed for all parties to present their full case without upsetting the status quo. Here, on the underlining, the first factor is that we believe Marathon is likely going to succeed on the merits. And the reason is because the division undertook a fundamental error in its analysis by failing to make use of the Commission's clear precedent where there's contested cases involving partially overlapping acreage in the competing development plans. For at least 6 years, that Commission precedent has required that there be an evaluation of the acreage that overlaps between the two project areas. And the evaluation is what is the working interest control in that acreage, not the ownership, but who has the greater percentage of the working interest control. Now, the division ignored in its analysis, in its findings, and its conclusions that Marathon has 100% working interest control through its joint operating agreement in the north half of Section 2. It never made the required finding under the Oil and Gas Act, Section 70-2-17, subparagraph E, that Powderhorn's plan is necessary to prevent waste before it subordinated, overrode Marathon's joint operating agreement to the compulsory pooling order. Now, applying the correct three-part partial overlap test that the commission has established in these partially overlapping competing development cases that has been used since at least 2020, the division made no finding that Marathon's plan would strand any acreage. That's one of the first steps, is to determine whether any of the plans would strand any acreage. The division made no such finding, so there's no risk or concern there. Powderhorn's superseding JOA theory, the idea that they have a superseding JOA among all the other parties that overrides our JOA, is a legal nullity. For that to have any effect, all parties to the underlying JOA would have to agree to their JOA, which isn't the case. And no party takes the position that Marathon's 100% voluntary agreement is invalid or void. Now, the precedent, the commission precedent that I'm referring to in particular is one case that I'm going to refer to as the BTA case. And Powderhorn invokes that in its response brief, saying that it cuts against Marathon. But in fact, the opposite is true, because in that case, the commission made clear that working interest control and 100% JOA controlled by a party governs. And the record here, in this case, mirrors the facts that led the commission to protect that JOA and the operator in the BTA case, and that operator's rights to fully develop their own interest under that JOA in order to protect relative rights. As in the BTA case, where the commission found that BTA should be able to develop its own JOA acreage, and in that case it was Marathon at the time, could go on and develop its own other acreage that partially overlapped, as was the case there. In this case, Marathon's plan lets each party develop the acreage it controls. Marathon can drill its JOA in the north half of Section 2 with 1 mile wells, while Powderhorn remains free to develop its acreage in the east half of Section 3 and in the south half of Section 2. They can go ahead and develop each of them 1 mile wells. That's the very outcome the commission precedent predicts based on the underlying cases and the precedent that the division until now has faithfully applied. Between the two development plans, only Marathon's protects the relative rights of all parties by allowing them to each fully develop their own acreage that they control. The case that Powderhorn relies on, a recent division case, in which the division made an adverse decision contrary to the commission president, is not binding, it's not authoritative, it's not persuasive. It was merely an erroneous decision entered by the division rather, that was challenged by the adversely affected party, went to commission on de novo, but didn't actually get heard because the parties resolved their issues. And so it carries no persuasive weight. On the second factor, Marathon will suffer immediate irreparable harm without a stay. If Powderhorn is allowed to go forward and drill or continue undertaking efforts to commence drilling and even to complete its wells, it will effectively perfect its rights under the challenged order and de facto extinguish Marathon's operating rights under the JOA before Marathon ever gets its statutory day before the commission. Once Powderhorn drills and completes the wells in the overlapping acreage, reservoir depletion through parent-child effects becomes permanent and cannot be remedied after the fact. Marathon's operational control under its 1976 JOA, its contractual right to operate its own acreage with 100% voluntary commitment will be effectively extinguished, and the JOA itself will be rendered a practical nullity, as the commission found in the BTA case below 6 years ago. That's precisely the dilemma the commission confronted in the Kotera, Reed and Stevens case, where the commissioners asked whether denying a stay would allow wells to be drilled before a de novo hearing would itself constitute harm to the objecting party. And the commission answered that question by granting the stay. And that the commission ultimately ruled in that case for the non-movement, Permian or Reed and Stevens, does not diminish the point. A stay protected the process itself, ensured that there was a full statutory right to de novo, and that's exactly what Marathon asked for here. Third, the balance of harm favors Marathon. Powderhorn's claimed injuries, rig commitments, midstream obligations, sunk costs, these are all risks and costs that Powderhorn voluntarily assumed itself with full knowledge that Marathon had a de novo appeal right. And if it continues to do so, it's under its own risk because we've sought this stay. Powderhorn's own motion papers concede that its financial commitments were preliminary to this point: surface staking, water contracts, takeaway negotiations, not the type of sunk costs that would outweigh Marathon's irreversible loss of operating rights. For example, Powderhorn still hasn't filed for APDs. Okay, they still don't have APDs, so no harm. If Powderhorn truly controls, as they say in their papers, the undisputed acreage in the east half of Section 3 and the south half of Section 2, if they've got 100% voluntary commitment, as they say, from all those parties, Powderhorn can go ahead and drill under a voluntary agreement. They don't need to wait for the commission or division. They can do so under a voluntary agreement. That's acreage that we're not disputing. We don't own in that acreage. And as they say, they have 100% commitment and 100% voluntary agreement. They can go ahead and drill those wells. They can perfect their term assignment that they're worried about expiring by drilling a single well in any of that acreage. We're not disputing their right to control it, their right to operate in that acreage. It's solely the north half of Section 2 where we have concern. A stay, especially as to the disputed acreage, would preserve all the rights, especially the rights of Marathon and its 1976 JOA. Fourth, the public interest demands a stay. Public interest is served by ensuring that the division and the commission follows its own precedent before the state exercises its police powers and compulsory pooling to override a 100% voluntary working interest that is operated by Marathon here. That means that predictability would be served in the division's regulatory framework so that every operator, working interest owner in New Mexico can understand and anticipate how this is going to play out. Allowing an order that departs from controlling precedent to take irreversible effect before the commission can even review it undermines that framework. So again, the twin purposes, the main obligations of the division and commission is to prevent waste and protect correlative rights. And you'll see in our papers, we make the point that New Mexico appellate courts have made and identified that protection of correlative rights is tantamount to preventing waste. If correlative rights are not protected, then waste will occur, which is precisely why back in 2020, when evaluating these types of cases with partially overlapping spacing units, the commission determined that in such particular cases, the particular category of cases, it's imperative to evaluate whose plan will best protect each party's ability to operate its own acreage. And that's why they look at the overlapping acreage to determine which plan best protects correlative rights. And here, the division didn't do that because it didn't take into consideration Marathon's 100% JOA in the north half of Section 2, and instead evaluated all the working interest on a whole project basis based on Powderhorn's project. So overriding Marathon's correlative rights by effectively nullifying its JOA is tantamount to causing waste because it would not protect the correlative rights under the JOA. Again, public interest is best served by ensuring that does not happen before the commission has a full and fair opportunity to hear the merits in this case. Finally, a couple of comments on Powderhorn's counter-arguments. Powderhorn makes the point that Marathon has no rival development plan, no affirmative case before the division or the commission, which is just not true. Marathon's plan is to develop its own JOA directly itself, and the Oil and Gas Act and the commission's precedent give preference to a ready, willing, and able JOA operator over a forced pooling proposal, and that's clear when you look at the statute 70-2-17 subparagraph E, which makes clear that voluntary agreements among parties to develop a pool should be overridden only by the commission or division if in order to prevent waste. And here, the division made no finding that Marathon's proposal would result in waste or that Powderhorn's proposal is necessary to prevent waste. That finding is missing, and such a finding is necessary to overcome the clear statutory directive of the Oil and Gas Act. Underlying commission precedent makes clear that proposals under a JOA are given equal weight to a proposal under a compulsory pooling order. There's no difference in the same factors, the same analysis applies. So of course, Marathon does have a rival development plan before this commission, as it did before the division. Powderhorn calls the 1976 JOA dormant and a vertical well agreement outdated, but nothing in its language limits it to vertical wells. It remains active. There's no dispute that it's an active and valid voluntary agreement. It currently supports production in the acreage, and no party, including Powderhorn, disputes its legal validity. It would govern all production from the acreage at hand, including horizontal wells. So the effort to phrase this old JOA as dormant and no longer active is just not valid. We did fail to provide a proposed order, and that was an error on our part. We did submit one as part of our reply brief. That is a non-substantive issue that can be easily remedied by the commission. I think the similar thing happened in the Coterra Permian case, where the applicant for the stay neglected to attach an order. The commission overlooked it and issued a stay nevertheless. Powderhorn also argues its term assignment deadline creates irreparable harm. As I pointed out, the de novo process will run its course over time regardless of a stay, and a stay does nothing to delay the ultimate resolution of the case. It simply preserves Marathon's rights while the process plays out. As I also stated, if Powderhorn truly has 100% voluntary commitment for the east half of Section 3 and the south half of Section 2, it can go ahead and drill wells in those tracts to preserve and perfect its term assignment rights. The change in ownership, which is not of record in the case below, that we understand has occurred, often is the situation when one party prevails at the division, parties will sign on to that party's proposal. It doesn't change the impact of the analysis by the commission. Marathon still owns over 55% of the interest in the south and north half of Section 2, and it still controls 100% of the working interest in that acreage. It doesn't change the outcome or the analysis under prior commission precedent one bit. Finally, Powderhorn raises the concern that if the commission were to adopt Marathon's arguments in this case, that a JOA somehow supersedes or has controls the development in acreage, that the commission will create a perpetual veto for every legacy JOA in the state. But the statute that governs and gives a preference to JOAs and voluntary agreements, 70-2-17E of the Oil and Gas Act, has been around since the start of the Oil and Gas Act, and this has never been an issue of concern. There's never been a rush of any kind to weaponize JOAs, because a JOA contract area must be of sufficient size to allow for horizontal well development and the right orientation. And that just hasn't been the case in all that many instances. Plus, a JOA operator, in order to compete with a compulsory pooling application or proposed plan, needs to show that it's viable, it has a plan that's viable and ready to go under the JOA. And here, Marathon has demonstrated that. It has APDs in place. It is ready and able to slot in these wells into its rig schedule. It hasn't yet drilled the wells because an order has issued from the division designating Powderhorn as the operator of the acreage. And of course, Marathon wouldn't do something contrary to a division order. So it has challenged that order here. And upon resolution, hoping that Marathon would prevail, it is ready, able, and willing to go forward with its drilling plan. Commission Chair and Commissioners, Marathon satisfies all four of the factors under the analysis. And it's likely to prevail because the division applied the wrong legal test. It faces irreparable and unrecoverable harm to its operating rights absent a stay if Powderhorn were allowed to go forward and drill. And the balance of harms favors Marathon because Powderhorn's exposure is self-created and manageable through having a quick and streamlined hearing before the commission. We support having a quick hearing and we have no interest in dragging it out. Finally, the public interest favors adherence to established precedent and protecting credible rights and ensuring that the commission is able to be deliberative in its process on de novo cases. We ask that the commission therefore grant the stay and allow the parties to proceed to hearing in a timely manner. We appreciate consideration happy to address any questions.
I'll turn to the other party at the moment, and we'll come back for questions all at once at the end.
Okay. Thank you, Mr. Commission Chair. So the issues that we're discussing today have been extensively briefed, so I'm not going to repeat all of them. I do want to visit on some of the things Mr. Rankin has talked about. Number one, the burden here is marathons. They have to prove two things. One, they have to follow 1915-423, which says a stay can be granted where it's necessary to either protect correlative rights, prevent waste, to protect health and environment, which is not an issue here, or prevent gross negative consequences. So they have to get one of those four. We, as briefed, and I'm happy to discuss for questions, we feel those factors weigh in favor of Powderhorn. Second, the New Mexico courts are clear that in order to be granted a stay, the party has to satisfy all four of what are commonly referred to as the Tenneco factors. That's you're likely to succeed on the merits, that there's irreparable harm to the movement, there's no harm to the non-movement, which is particularly at issue in this case, and there's no harm to the public. So as we've briefed, these two standards, we do not believe they're met. Let's just take first the likelihood to succeed on the merits. If we look at the post-order working interest consolidation, Powderhorn has acquired approximately 82% of the ownership in the broader Super Hornet unit that was approved by the order. That's pretty significant consolidation post-order, and that's something that the commission in 25371 or 25371 specifically looked to as a factor in favor of Permian resources. So that is a factor that we want at the division level. It's only stronger in our case now. Second, Marathon hasn't brought forth any new evidence at the division level, which is the best analog to how we think a decision would be made in this case and the likelihood to succeed on the merits. Powderhorn won on 6 of the 7 factors. This wasn't a close game. The only factor that they didn't win on was decided to be neutral, and that's prudent operatorship, and that really wasn't much of an issue in the case. All right. Mr. Rankin relies a lot on the stay issued in 25371. That's the Joker Bain case. The facts in that case are just decidedly different than the facts we're faced with here. For one, the fight in that case was over wells that the movement did not believe need to be drilled at all. And they said part of the discussion was once you drill a well, you can't undrill a well. And that's what we're trying to prevent. In this case, the operators are targeting the same bench, same orientation, same spacing. The only difference, the only fight is, do you drill 1.5 mile laterals and who gets to operate? So that's the fight here. So this is not a situation where there is an alleged harm that can't be undone under the provisions of the order. Second, in that case, there was significant harm alleged by the movement. There was like approximate $200+ million economic waste claim. We don't have that here. In fact, the harm runs the other way. Powderhorn's committed millions of dollars in midstream that would be harmed if this stay were granted. And we also have the issue of the term expiration. We talked about that. No need to elaborate there. There are also other knock-on effects that would cause harm to Powderhorn. As a smaller operator, they have longer lead times for arranging rig contracts. Right now, the rig contracts are currently being held open because of this stay. If those expire, that will be really difficult and a big challenge for Powderhorn to overcome. But I guess really I want to use the balance of my time talking about this idea that under 7217, that E controls that. Number one, the division, who's had more recent at-bats at this, Mr. Rankin relies on, a 6-year-old case, which is still valid, as persuasive precedent. It's not binding mandatory precedent. But the division has looked at this several times, and they've come to the same conclusion. They say where the JOA acreage is one component of a broader unit, that JOA, the fact of that JOA does not bar compulsory pooling within the broader unit. So there's 2 components that are at issue with 7217. One is C. C says where there's no agreement to pool, the division may pool the interests. E says where the parties have agreed to pool, the division may only modify on the finding of waste. So in this case, the acreage Marathon has a valid JOA on is it's approximately 30% of the entire proposed Powderhorn spacing unit. We believe under those facts that 7217C controls, because there is no broader agreement to pool Marathon's interest within that larger spacing unit. And that's the whole basis of the hearing we had, and that's the whole basis of the hearing that we won. And we feel that if subsection E were allowed to essentially subsume section C, this would grant an automatic delay for every single order granted in the state. If you look at the title, most acreage that's being developed today, including this, it's legacy acreage in the sense that it's being held by conventional production that was drilled a long time ago, and it's subject to JOA, and we're now having to piecemeal smaller tracts into larger horizontal spacing units. If we have some sort of policy or precedent where any JOA within a broader spacing unit is allowed to block development, we're going to be at this, we're going to have this fight virtually every single time that we seek to pool that acreage. What's more, the factor of working against control there, even if we were to take Mr. Rankin's argument that the working against control only in the overlapped acreage controls, it's one factor of 7. It's one. And in the BTA case that he refers to, BTA had an overwhelming majority. They had an 82% ownership in the unit. Here, Marathon has 55%. Powderhorn owns or controls 45%. So this is not the same case. Then I want to go to, real briefly, this idea that Powderhorn assumed the risk by operating under the order. Number one, they received an order, they waited 3 weeks, they started moving. As I mentioned, the timelines are different for a smaller company. If we were to operate this blanket rule that it's unreasonable to begin to operate under a valid order, then I want to take a look at the timeline, what that's going to do to operators. So that means effectively you have a 30-day stay after an order. We've now shrunk my order time from 12 months to 11 months. I need to have a hearing. That's another, let's call it 20 days to be generous. Now we're 50 days into my hearing order. Then it gets set for de novo. I'm going to wait another 120 days. Then, assuming the commission acts quickly, we got another 30 days to wait for a hearing. That gets us to 200 days into the order. That leaves us only a little less than half of the order time to execute. So we think that's bad policy and should be considered by the division. Finally, under the 4-part Tenneco test, again, that issue is extensively briefed, and I don't want to re-go over all of it, but I do want to focus on one factor that Mr. Rankin leaves out in his argument, and that's factor number 3, that there's no harm to the non-movement. In this case, we have outlined that there will be significant harm to the non-movement. There will be a potentially $2.75 million hit on a midstream deficiency if we're not able to proceed with development as we would like to. A term interest could expire. We could lose a rig. These are all things that would cause significant harm to the non-movement in this case. And finally, Powderhorn does have APDs, where they were granted this week. So you probably didn't know that, but to the extent that's a factor. So I'll stand by for questions, and we ask that the motion be denied, that the stay be denied. In the alternative, if the commission's inclined to grant it, we would ask that we would get a very narrowly tailored order that doesn't prohibit all activities. So in the Joker Bain case, it enforced a mandatory shutdown of all planning, everything. Here we would ask only that the prohibition be against spud. Second, we would ask for as tight of a timeline as we can get to get the hearing, because we're under significant time pressure here. And third, we'd ask that the division enforce or require of Marathon a bond sufficient to cover these liquidated costs that could be incurred by Powderhorn. Thank you.
Thank you. Is OCD planning to weigh in?
No, with the various legal arguments on compulsory pooling cases, I'm monitoring to stay abreast. We're not entered in appearance.
Thank you. Commissioner Mpoma, would you like any replies or responses from the counterparties, or do you have questions?
Mr. Chair, so just want to be sure that we are just listening to the the stay, the motion to stay, and not necessarily the de novo, or is all combined?
Oh, no, well, so that's a great question. So the way I understand it, and council can object if or advise if I'm getting this wrong, there is a automatic right to a de novo hearing, but we're not hearing the whole de novo hearing today. It is merely, but I do want to make a distinction because I do have different sets of questions. One is on just the actual status, right? So the basic mechanical questions of have the parties tried to mediate? Have you guys met and conferred? If this is to go to a hearing, how many witnesses? What part of the underlying record can you possibly stipulate to save us the, save this thing from truly being a full-blown de novo? And so all of those mechanical questions of what does the de novo hearing need to be, right, in terms of the actual status conference part of it. And then the second part then is the motion for stay, which I think which is what the parties we're just debating, which is the commission inclined to grant a stay of the division order pending the de novo until the de novo hearing can occur?
Then my question to Power Horn will be, so Mr. Rankin was talking about the fact that, and even you alluded that it's only about 30% overlap. Is that correct? So, and then you are also saying that if the commission decides to grant a stay, you want it to be very narrow. But I did not get all the latter part, the conditions that were given to the commission as to, let's say, whether if we decide to grant a stay, it has to be within that narrow window. So is it also your understanding that probably PH can continue with the activities, but let's say there will be a stay on the acreage that is in contention?
Sure, so I'll take those in parts. One, our requests for, to the extent there is a stay granted, that it be narrow, is a request that the division operate under its discretion, right? That's up to you guys, and we fully respect that. As to the layout of the tracks and could Powderhorn operate ignoring this overlapped acreage, the answer we feel is no. This was discussed. I know this is not a hearing on the merits, but I think it requires some discussion because this was discussed extensively at the hearing. This rectangle is bounded on the east and west by existing development already. So we already have drainage on both sides. There is planned development within 1 year to the north, and that from Mewburn that we believe is going to happen in the next 12 months. So that's going to, now we're going to have drainage on east, west, and north. If we were to drill, because the parent-child question was, there was a big question at the hearing. If we were to drill the south half of this acreage, now the north half of not only section 2, but the northeast quarter section 3, it's going to be quadruple bounded by existing production. And then we feel like that could effectively condemn the acreage. And so that would do two things. That would want, and now I'm not an engineer. That's just what the information I have. And we feel that would have two things. One, it would harm the acreage to the north, and it could potentially strand that northeast quarter in which the state of New Mexico owns minerals.
So like Chair said, Marathon is also, they have the right to de novo hearing, right? Which we will more or less hear about all of that. So how do you square that? Because definitely, if let's say a stay is not granted, you go ahead and then you continue drilling. You said a well drill cannot be undone, right? So definitely, don't you believe that they do have the right to de novo? So they need to be heard, about their case. And you also more or less argue that they do not meet the 4 criteria, to grant the stay. So I'm still trying to square that. They have the right, and then also you feel like they've not met the burden. So help us understand where the line is.
Sure, I'll do my best. So we have two things at issue. One, the statutory right to de novo. Agreed, no argument. There's no argument there. The second would be the stay pending the de novo hearing. That we contest, and we ask that you deny that. There are significant, it's an extraordinary remedy that you can grant to preserve the status quo if necessary, but there's certain considerations that must be made. One, as I've briefed, we have the 1915-423, one of four factors: protect health, protect correlative rights, health, all that sort of stuff. So that's one thing, that's one hurdle that the applicant or movement has to meet. Second, New Mexico courts have made clear that to impose this extraordinary remedy, they have to meet a four-part test, and they have to meet all four elements of that. And that's where we don't feel. So to the extent our argument strayed into merits, at least from my perspective, I don't want to speak for Adam, but to the extent I strayed into merits, it was to rebut the first factor of likelihood to succeed on the merits. We feel that Marathon has not carried the burden in that respect. We also feel that there is documented, quantified harm to the non-movement, in this case, it's Powderhorn. Now, to your question of could Powderhorn go out and drill a well in the time before we have a de novo hearing, I guess that's academically possible. I would defer to the technical experts on that. I think it's extraordinarily unlikely from a timing perspective, and I'll just leave it at that.
Then my follow-up will be, so you said you don't necessarily have any problem with the de novo hearing, right? You said that. But you do have a problem with the stay. Now, and then one of your arguments is that Marathon will probably not prevail. So don't you believe that the commission needs to get the opportunity to listen to that argument, to make a determination whether they are not going to prevail?
Sorry. I said that I said they have a statutory right to a de novo appeal. I don't think we agree that we should have one, but that's we're starting to we're cutting it pretty thin there. As to the stay, I think our ask is that, again, it be denied, and if it is granted, we ask that it be narrowly tailored so that we can continue to plan, because we do feel that we will succeed on de novo hearing. We feel that Powderhorn should be allowed to, within the commission's discretion, to do all activities short of spud, so that we're not prohibited from negotiating contracts, takeaway, ordering casing, inspecting casing, just all the things that go into drilling the well. In the order that was issued in 25371, it was a full stand down, nothing, no action could be taken at all pending the de novo appeal. That would be really restrictive. I walked through that timeline of what that practically is going to look like for Powderhorn. Even if we succeed on the merits at de novo appeal, that de novo appeal does not stay the order. So now we've shrunk down our time to perform to 165 days from 365 days. So we ask only that the order be narrowly tailored to prevent if the concern is spud and wells in the ground, that we feel that the order should be directed solely at that and not broadly to prevent all planning activities.
Just to follow up on that timeline thing, if a de novo hearing, well, de novo hearing must be granted because there's a statute or there's a I can't remember whether it's a statute or regulation, but either way, there's a rule requiring that. Under de novo, though, wouldn't the commission be able to issue a new 12 months timeline? Because wouldn't the de novo wipe away what the division did, and including that timeline, and be able to give you a full 12 months when the commission did issue an order on the de novo?
I suppose it could. In this case, the facts are a little different because Marathon's not putting forth a competing plan. They're standing on their JOA acreage. We're standing on the order that was granted. I mean, that would certainly be something we would ask to the extent it's not automatically granted.
Thank you. And did either party file a map of these contested acreages by any chance? Because I'm having a hard time finding one, and I'm really having a hard time tracking which acres are which without some visuals.
Understood. I believe, Mr. Chair, that in the reply brief, there is inserted in one of the pages a demonstrative that shows how the acreage is oriented. Unfortunately, I left those piles of paper behind, but it's on
page 9. It's okay. I think I know. It's not an attachment. It's in the actual body,
inserted image.
Is this the
Figure
one?
1 on the reply brief,
Okay.
I think is what I called it. And it shows where the orientation of the contested acreage being the north half of section 2, and I can't tell you the township or range, and how that is situated within the greater Powderhorn proposed Super Hornet unit, which would comprise all of section 2 and the east half of section 3. The north half being approximately 320 acres.
So Marathon does, so the blue on your map, which you're not looking at, so I don't even know if this is going to make any sense to you, but I'm assuming this is north, south, east, west oriented. So the eastern acres, Marathon has no interest.
So would you mind flipping it so I could see real fast, Mr. Chair? Yeah. So it's the north half of, that would be, that's Powderhorn's interest right there.
And Marathon, no interest.
We have no ownership in there.
Okay.
Don't care about it.
Okay.
And the south half, the red acreage,
Yes.
which says Avant, is now Powderhorn. When that exhibit was made, it was unknown to us that Avant and Powderhorn had made an agreement.
Got it.
So now both the south half of section 2 and the east half of section 3 are controlled by Powderhorn, and we do not contest that acreage one bit.
Okay. And
so all that is contested is the north half of section 2, which constitutes Marathon's JOA acreage.
is that your understanding as well?
Yes, that's correct. And there's, to the extent they're needed, there's a plethora of plats in the underlying exhibits for the hearing. Sure.
Okay. I think what Commissioner Mpoma and I are struggling with is, and we've struggled with this in previous cases, is that the standards, a stay is indeed an extraordinary remedy, and the factors for a stay are phrased in somewhat stringent terms. On the other hand, if we don't grant a stay and there ends up being some, or there is development, it becomes really, really difficult, to Dr. Mpoma's point, to try to unwind or remedy should the commission come to a different conclusion, right? So I think we're trying to figure out the most prudent way to thread that needle here. Do you have any, I interrupted you earlier, Commissioner Mpoma. Did you have any further questions for either party at this point?
Mr. Chair, I do not. I do not.
Okay. I think the point to be, if we were to go ahead and grant any sort of stay, to be as narrow as possible is fair. We certainly want to be as judicious as we can with how we proceed. So let me, and I think both of us are still trying to figure out how to handle the state issue, but let me turn to the actual underlying, just sort of the pragmatic matters as to what the de novo is looking like. Could you, each party, advise on some of the just procedural mechanics of what we're looking at in terms of the de novo hearing?
Mr. Chair, Adam Rankin, I'll step in first. Mr. Holliday and I have not yet fully discussed. At a high level, I indicated to him, without conferring fully with the client, that I think there's a lot of things we can stipulate to. This is primarily a legal issue, which is why we didn't present any new evidence in our motion for stay. It's primarily an argument that the division misapplied the commission precedent and the requirements of the Oil and Gas Act. So I think much of what was addressed and presented below can be stipulated to. There's some updates, I think, as to ownership interests. There may be some issues regarding development plans and engineering that we would want to make an effort to clarify, that we think the division misunderstood. But otherwise, I think we can certainly get this done in a day. I think there's nothing that would prevent us from getting this full hearing done in a single day. And Marathon's interest here is to try to to streamline the process to satisfy any concerns from Powderhorn or the division, or commission rather, about impairment or harm or delay. So that's number one. So I think probably we would need 3 witnesses. just to touch on those issues, but I think much of it could be stipulated too. So I think the testimony would be fairly streamlined. We'd be happy to submit written testimony, which we think would also curtail time on the stand and make cross more efficient. And then also we're happy to have a hearing as soon as possible. Another point that you brought up, Mr. Chair, was whether the parties had yet conferred or attempted to make resolution. The fact is not yet, but I can say for my client that they're open to it. They're hoping to engage discussions. I think we need to get the stay issue out of the way first before we engage in discussions. But I can say that I believe that, that at least for Marathon's part, there's opportunity for discussions and potential resolution.
Mr. Holliday.
I'll agree with some of what Mr. Rankin said. We have conferred on a high level. Powderhorn is willing to take efforts to streamline issues at the hearing, at the de novo that perhaps we can agree to. I would push back a little bit on the idea that it could be conducted in one day. I mean, this is a full-blown de novo hearing. We're going to want to present all our evidence and all our non-stipulated evidence and witnesses and things like that. So I want to push back on expectations there a little bit. The second is we feel that the negotiation posture in this case, from Powderhorn's perspective, they've made multiple offers. It's somewhere in the neighborhood of north of 15 offers, and there hasn't been a single counteroffer. So we have I think we've exhausted what we're willing to offer. Our request would be that, and this is a matter I know for Mr. Rankin and I to talk about. Our request would be let us know what's in the ballpark of acceptable, and then we can work with that, because from Powderhorn's perspective, a lot of things have been proffered and we haven't received any feedback other than no. So I think there is a willingness to negotiate. I appreciate Mr. Rankin and Marathon's willingness to do this on a tight timeline. Happy to answer any questions if you have more.
Fair enough. So from the commission's perspective, I'll just speak for myself, but I think Commissioner Mpoma will agree with me that from our perspective, the more that you guys, the parties can resolve the issues, the happier the commission is with everybody. And the less likely the commission is being put in the position of making everybody unhappy. So certainly whatever we can do to encourage your respective clients to talk to each other and try to resolve these issues on their own without the commission's intervention, we certainly will be happy to do whatever we can to encourage that. Number one. Number two, I hear you on the fact that you may want to the de novo. You're correct. It formally wipes away the original underlying hearing and sort of requires, but the more that the parties are willing to stipulate to the existing underlying record and simply import that as the factual record to the commission so that we can treat this more like a record review with less new evidence, the faster we can get you on the books for a hearing, right? So the faster we can help your client get resolution on this and get finality on this. So I would encourage, if a witness has already testified at the division level, to see however much of that testimony that the parties can stipulate to simply adopt. Especially since, again, speaking only for myself, I don't know that this is the formal position of the commission, but a witness's prior inconsistent testimony could be used for impeachment. So it would seem to me like there is some benefit to adopting what they've already said as opposed to creating an additional record. So that said, I know that facts can change and things like parties' ownership facts or underlying facts may have changed since the division case. So if you need to put new factual evidence into the record, that's certainly allowable. So, okay. I know Mr. Rankin has said he's got hopefully 3 or less witnesses that he's thinking about presenting. Do you have Mr. Holliday, do you have a sense of how many witnesses you might need?
I would assume we would have the same 3 as at the hearing. Yes, sir.
Okay. Commissioner Mpoma, are you ready to have an opinion on the stay and or any other issues related to how we want to organize this hearing?
Yes, Mr. Chair, I do have opinion. And it still goes back to the fact that, let's say, Powder Horn is saying that Marathon will not prevail, let's say, even in the de novo, right? So I want to see the evidence as to why they believe that Marathon will not prevail even in the de novo. So with that, I am leaning towards more or less granting the stay to know whether they meet all the four, during the de novo hearing. Other than that, we more or less miss the opportunity to also listen to their portion of the situation. So I'm leaning towards granting the stay pending the discussions pending the de novo hearing. And I'm open to also discussing if we want to make it more narrow to minimize the impact. I'm open to that as well. Thank you.
I feel, yeah, okay. So I think we're all on the same page of trying to minimize to grant some sort, so to minimize potential harm to both litigants here. I think we're going to grant we're going to grant as limited of a stay as possible to preserve as much of Powder Horn's ability to to prevent as much impact to Powder Horn as possible by the de novo proceedings, and we're also going to see if we can provide some sort of narrow scope of a stay, so that we also don't create an unwindable mess to the extent possible for I want to say good night, but it's not good night. Marathon. Okay. I think that will take a little bit of wordsmithing and thinking on my part, so I don't know that I have anything to announce right away, but I will run a draft past my fellow commissioners, and we'll take, or go ahead.
If I may, Mr. Chair and Commissioner Mpoma, just to address that point, as we stated in the briefing, and I'll say here again, that the point of this de novo is to protect Marathon's interest in its JOA, which is limited to the north half of Section 2. And we have no dispute and no basis to contend that Powder Horn doesn't have the right or ability to go forward with development elsewhere on those tracks. And as based on their own representations, they have 100% of the interest or control in those tracks. And if that's the case, they should be and could, under a voluntary agreement, proceed with that work towards that acreage, even in the event they lose at de novo. The work that they've done would not be in vain, would go towards the development and drilling of those tracks. And so, again, that weighs against their harms, but that is the kind of thing that I think is appropriate here. We just don't want to have anything that would impair Marathon's ability to develop its own acreage at this point, and ask that in terms of a narrow stay, it just preserve the status quo as to the north half of Section 2.
I will thank you, and I will do my best to draft it as geographically, temporally, and specific activity-wise. I'll draft something as narrow as I think the commission, and the commission takes both your points, that we're trying to be as careful as possible to minimize impacts to both parties. And I am happy to commit to working with our commission clerk and respective councils to try to get the de novo hearing, get to the actual hearing on the merits of the de novo as quickly as possible. Our docket is a little full, but I'm sure we can find some way to make that happen sooner rather than later for all parties. Go ahead.
On that point, Mr. Chair, shall the parties confer with Commission Clerk to determine potential available dates after this hearing?
Yes, I think that might be the best way to go about it, since yeah, that's probably the best way to go about it. And I, once again, encourage both parties to try to settle, even if you don't settle all of the issues, if there's any, I know a lot of this is legal, so it is what it is, but the more that you guys are even able to agree to stipulate on any factual issues, anything that can help us it's just putting it out there that it's easier to calendar a one-day hearing for the commission than it is to try to calendar a three-day hearing, right? Just trying to find for 3 days on the calendars of all three of our members is more challenging than one. So the more, the better. And I think the commission highly encourages the parties to at least meet and confer, and we'll do our best to also schedule something as quickly as possible. Okay, and with that, I think I have some general instructions on how to write or what to do about the stay. I'm going to draft up something and then I'll send it around to the commission and commission council to review. But for today's purposes, we'll take the motion on the stay under advisement. Okay, thank you all very much. That concludes the cases in front of us. Commissioners, are there any other business to discuss that you would like to discuss?
Not from my side.
Commissioners, thank you to the parties. Is there any interest in going into a closed session to discuss pending litigation matters? Or would you prefer to work for Commissioner Bloom for that discussion?
Yeah, so that was my items to discuss, but I'm not sure since Commissioner Bloom is not here, I'm not sure. So I'm just on the fence, I'm not sure. But the timing too, because our next meeting is going to be July 27th, and it's all full week. So even I'm wondering if it's possible we can squeeze some time within that to get Commissioner Bloom here so we can get into closed session to discuss that, if we have time for that.
Okay. If that's, any objections from Commission Council?
No objection.
Okay. In that case, I think I'll take I agree with the advice, so I'm going to ask our commission clerk to try to put a special on our calendars as quickly as possible. When Commissioner Bloom is, all three of us are available, well, all four with our commission counsel, so that we can get a litigation update in closed session with commission counsel. And in that, we'll make a quick announcement that the next meeting of the OCC that's currently calendared is the special OCC meeting on July 27th, 2026. And with that, I'll take a motion to adjourn.
I move that the meeting gets to a close. Thank you.
I will second that, and without objection, hearing no objection, we're adjourned. Thank you all very much.